You claim in your accident or medical malpractice case that you cannot run anymore because of what happened to you. But then you absentmindedly tweet to your friends that you just finished a great game of basketball. How is that going to affect your particular case? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. With the advent of social media, people inadvertently put all sorts of personal things online, whether it's on Facebook or Twitter or LinkedIn. Well, guess what? As a result of that, the defense has actually hired all these social media investigators to track down information about these litigants. And I guarantee you that they will scour your Facebook page, your Twitter page, and everything that you've done online. And if they find information that contradicts what you are claiming in your particular case, I guarantee you that at trial the defense is going to use it against you. And they're going to box you in, and here's how they do it. They're going to ask you, Mr. Jones, have you been able to walk since the time of your accident? No, not at all. I'm bound, I have to use a cane, I have to use this. I can't do the type of activities I used to do. How far would you be able to walk? And how far can you walk today? Why are you unable to walk? Have you tried walking? Now, what they're doing is trying to box you in and lock you into specific answers. Now, once you tell them that you can't do all these activities, they're going to pull out information from your own personal social media, and they're going to ask you questions about it. Mr. Jones, didn't you post on Facebook that you played a game of basketball only 2 weeks ago? Oh, no, somebody else must have done it. Really? Here's a printout of your particular Facebook page. Isn't this you? Didn't you post on Twitter that you just finished a great game of basketball? Oh, no, that must have been somebody else. And now you're stuck trying to explain away those different postings that you put on your own social media. The bottom line is, if you are posting things that contradict what you have testified to in your particular case, I guarantee you the defense is going to find that information and use it against you at trial. And you should know that your credibility is the most important thing at trial. And if the defense is successful in destroying your credibility by showing that you have lied about one particular thing, even if it's a small thing, at the end of the case, they're going to turn to the jury and say, listen, how can you believe him? He's lied about one small thing. And if he's lied about one small thing, how can you believe all the other things he's told you about? So why do I share this great information with you? I share it with you because social media has played a huge part nowadays in today's cases. And if you're not careful with what goes on, you're going to have a real risk and a real problem later on. I realize you're watching this video because you probably have questions or concerns about your own particular case. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. I do this every single day and I'd love to talk with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. I'm going to head inside now and put some stuff on Facebook about shooting a great new video. All right, everybody, have a wonderful day.